Ada County, Idaho, just agreed to pay $250,000 to this 70-year-old man to settle a lawsuit. Why? When Mick Hakela appeared just for a matter of seconds through the window of one of the police cars that Ada County taxpayers pay for in a public parking lot in broad daylight, he was accosted, attacked, and manhandled by police officers and then handcuffed, arrested, humiliated, and jailed. Though they charged him with resisting officers, the Idaho judge presiding over his case dismissed it, concluding that there was no way the prosecution could prove that Hakela had committed any crime. The court ruled that the officers had no lawful basis to stop, detain, or seize Hakela, much less manhandle, arrest, or jail him. He filed a lawsuit. Now, not only do they have to pay, but they have to make a public statement and retrain their officers. Michael Hakela goes by Mick. He's 70 years old. He's been married to his wife for 45 years. Together, they've raised 3 successful children. While Mick achieved success as a business owner and his wife taught in the Kuna, Idaho school district, where his daughter now teaches as well. He's a grandfather to 6 grandchildren and a homeowner in Kuna where he's lived for 35 years. This is a recent photo of Mr. Hakela and his wife that was actually included in his lawsuit. I pulled a copy of his lawsuit right off of Pacer, so everything I'm telling you is straight out of the allegations that the county paid to settle. Let's go through them, along with the surveillance footage showing what happened. About noon on an ordinary Tuesday, Mick Hakela drove to the Kuna police station. The station had one of Idaho's official prescription drug disposal boxes, where you can safely dispose of unneeded and expired medication. Hakela's pharmacy accidentally filled an expired prescription, but when Hakela took it back, they told him he would have to go to the police station to safely dispose of the drugs. He followed the pharmacy's direction and parked in the public parking lot just next to the police station in plain view of both the station and Kuna Middle School just next door. 2 marked police SUVs were in the stalls next to Hakela in the parking lot, situated closer to the station's front door. On his way inside to dispose of his medication, Hakela took a look at 2 police cars. He hadn't been this close to a police car in decades and was curious what his taxes were paying for. While peering in the window of the one closest to the station, a nondescript white car pulled into the parking lot that's shared by the middle school and the police station. It stopped before parking, and a man in a black jacket, black beanie, and khaki pants got out. Hakela had already turned to walk into the police station. Nonetheless, Hakela then heard the man yelling and aggressively approaching him. The man then asked Hakela why he was looking in, quote, our cars. Hakela, confused, said, my cars too, as a taxpayer. The man persisted, next shouting at Hakela to take his hands out of his pockets, to which Hakela, confronted with a sanctimonious stranger, responded, F you, and resumed walking into the police station. Hakela entered the station and chatted briefly with the front desk receptionist while depositing his medications in the secure drop box as uniformed officers barreled past him. The uniformed officers showed no concern for Hakela, who was now handing the paper sack he'd brought his expired meds in to the receptionist, who offered to throw it away. But then the officers turned back to Hakela and ordered him out of the building. One of the officers, Officer Justin Filial, told Hakela to take his hands out of his pockets. Hakela said no, but showed his hands briefly. In an instant, Officer Filial grabbed Hakela forcefully, and then all the officers in front of the station then grabbed Hakela and pinned his arms behind his back before slamming him into metal railings in front of the station. In almost no time, at least 6 officers were pinning Hakela to the railing, including the man from the parking lot in the black jacket, black beanie, and khaki pants. It turned out that he was a plainclothes officer named Brian Keene. He was driving an unmarked car and had not identified himself as a police officer to Mr. Hakela. The officers put Mr. Hakela in handcuffs and, still pinning him against the railings, began to interrogate him. Officer Filial searched Hakela for weapons and found none. Hakela had undergone invasive surgery just 3 months before. When the officers slammed him against the railings, he soiled himself. Officer Filial and another officer named Jacob Nidegger took Hakela into the station's interview room and continued the interrogation. At no point did any of the officers read Mr. Hakela his Miranda rights, and they even persisted interrogating him after he told them he wasn't going to answer any questions. Officer Filial confirmed to Hakela that he was under arrest, and eventually Hakela was put into a police car and then taken to jail. Mr. Hakela sat in his own feces all the way from Kuna to the jail in Boise. These police officers had already so humiliated, intimidated, and abused him. Hakela was scared to tell them about it lest they humiliate and abuse him even more. But after reaching the jail, he broke down and alerted Officer Filial that he had soiled himself. Yet even after he alerted Filial, Hakela had to continue sitting in his own filth until his wife could bail him out later that afternoon. These police officers then provided reports to the Ada County Prosecutor's Office intending to promote and further Hakela's criminal prosecution. Among other things, those reports alleged that Hakela was advised of his Miranda rights before officers questioned him. Officer Filial certified under penalty of perjury that statement was true and correct. But that statement was false. And the defendant officers, including Filial, knew or had every reason to know that it was false when they provided the reports to the Ada County prosecutor. Hakela was charged under Idaho Code Section 18-705 with resisting and obstructing officers. Pursuant to Idaho law, he demanded a formal complaint be filed against him, but the state never filed one. So Hakela filed a motion to suppress all evidence against him and dismissed the charge, arguing that Defendant Keene, and therefore all of the officers who accosted him after Keene, had no basis to stop him, much less order him to do anything with his hands. The court held an evidentiary hearing and concluded that the defendant officers seized and detained Hakela without reasonable suspicion. The court found that Keene did not pursue any additional investigation, explain his reasonings for the contact, or further reveal his identity or employment to Hakela. The court held that this court cannot find that reasonable suspicion existed to believe that Hakela committed or was about to commit the crime of burglary or theft, which Keene contended that he thought Hakela was doing by looking in the window of a marked police car in a public parking lot in front of a police station in broad daylight. The court held that Mr. Hakela's rights were violated, and then it dismissed the case against him because the charge against him cannot proceed or be proven. The state did not appeal that dismissal. The lawsuit appears to have settled rather quickly as far as litigation goes, didn't reach the point of depositions, much less getting close to trial. And that's not surprising because this was a completely innocent person who was not suspected of having committed any crime. And it's not a crime to look in the window of a police car. I mean, the cops do it to us all the time because the courts have held that you have no reasonable expectation of privacy through the glass of your vehicle. None of us do. That's why police officers can look into our cars, and also a great plaintiff because he was completely innocent and a jury would be really sympathetic to him. So it was a $250,000 settlement plus unspecified additional training to be provided to Ada County Sheriff's deputies. But then I came across this just today. It was an update on a news story. And this is a statement from Sheriff Matt Clifford, the Ada County Sheriff. And this is what he said. Earlier this week, we settled a lawsuit with Mr. Hakela stemming from an incident in January 2023. It wasn't our best day. It is the expectation that Ada County deputies perform to the best of their abilities every day while keeping people's constitutional rights in the forefront of their minds while also keeping our community safe. Clearly, constitutional rights were in the forefront of these deputies' minds that day. For anyone to claim we are trampling on someone's constitutional rights simply isn't true. I mean, why would anyone think that? I don't know. Why would you pay $250,000, $250,000, if that wasn't true? I can see where they get it from, because you, the sheriff, are also a liar. The reality is we have hundreds of contacts every day with people of all different backgrounds, religions, ethnicities, and socioeconomic What are you talking about? Did you write that yourself? This wasn't a contact. This was a guy dropping off his medications. You had no contact. You fabricated, your officers fabricated a contact. While the vast majority of those interactions go well, occasionally we fumble and miss the mark. And that just shows the respect that you have for the Constitution, Sheriff Matt Clifford. A fumble. The Constitution is not a game. It's not a football game. When constitutional rights are violated, it's not a fumble. Part of the settlement was to include additional constitutional policing training. Fortunately, we had already implemented this training prior to the settlement. Yeah, right. We will now also include a scenario similar to Mr. Hakela's in our scenario-based training. What's the scenario? Your officers attack a guy walking down the street for no reason? We are one of the few law enforcement agencies across the country with routine built-in training time. Every patrol deputy receives 9.5 training hours per month. You should ask for your money back. These blocks of training include topics such as firearms training, scenario-based training, legal updates, EVOC, de-escalation techniques. You need to give your trainer 5 stars for that one. Arrest and control techniques. Now, you are doing a good job with that. I mean, at least with 70-year-old men. CPR, first aid, and more. I can't imagine why your deputies would need to know CPR and other first aid techniques. I mean, they wouldn't hurt anybody, right? Like a 70-year-old man. Part of our culture at the Ada County Sheriff's Office is to always strive to be better. And learning from this incident will help us to do just that. Yeah, Matt, you should strive to do better than getting violent with a 70-year-old man and making him sit in his own for 4 hours. So there you have it. I don't know what else to say. The government violates a completely innocent guy, puts him through this terrible experience. They still try to prosecute him and even lie about it. The judge dismisses it. They're still defiant. They have to be sued. They agree to pay $250,000 and mandatory retraining. Yet listen to the sheriff's statement after the fact, or read the sheriff's statement. He's not sorry. They're not sorry. That's what they think of you. That's what your government thinks of you. They'll do this again. So that's all I have for you on this. I will post the full lawsuit at the blog post. Also, I will link the media reports where you can watch the interview with the individual himself. And he's very articulate. And he explains why so many people get so offended being treated like a criminal by the police. If you have a video you want me to review, please use the submission link below. Please subscribe both here and at the blog at thecivilrightslawyer.com. Make sure YouTube did not unsubscribe you like they've done so many others. Remember, our rights don't end where your fear begins. Freedom is scary. Deal with it.